Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. Today's video discusses how a buyer's broker should, in buyer's best interest, document buyer's reliance on state bond money for down payment assistance. And as our video producer, Steve Klinicki, likes to remind me, by the way, best video producer ever, we've done lots of videos on gifts from grandma for down payment assistance, but this is not a video about down payment assistance from grandma. There's a difference between gift funds from grandma and buyer's reliance on state bond money for down payment assistance. And what's the difference? When a buyer goes to seller and says, I'm relying on a gift from grandma, seller should be able to rely on the fact that grandma has that money in her bank account and grandma loves the buyer and is going to transfer the money to the buyer without a lot of question. Buyer doesn't have to do anything to get it. Buyer's already had a lifetime of love for grandma and gotten that and earned that money, if you will. Oh, I'm sorry, you don't earn a gift. You get it, you know what I'm talking about. And for that, it makes sense that buyer would document buyer's reliance on grandma's gift funds for down payment on Form 22EF. And then you look at line 29 of Form 22EF, where buyer is required to provide proof to seller that buyer has converted buyer's contingent funds to non-contingent funds. And I often say when I'm teaching class regarding grandma's gift funds, that sellers should require buyer to provide proof of grandma's gift funds much sooner than 10 days prior to closing, because again, grandma should have that money in her account and grandma should be willing to give that gift money. And if grandma's going to give it to the buyer at closing, why wouldn't grandma give it to buyer maybe within 3 or 4 or 5 days after mutual acceptance? So that's the gift from grandma concept. Why did I say that's very different from the state bond money down payment assistance program? Because buyer has no assurance from the state that buyer is going to get that bond money. Buyer's got to make application for that bond money and hope to get it. But much like buyer has no idea for sure whether they're going to get their financing or whether they're going to get it timely, buyer has no idea for sure whether they're going to get their down payment assistance money or get it timely. So if buyer were to use the same approach as we use for grandma's gift money and document it on a Form 22EF, then what Form 22EF says from buyer to seller is, seller, I'm 100% confident I'm going to get this state bond money. So confident, in fact, that if I don't worry about any other contingency I might have included in this purchase and sale agreement. Instead, I will be in default of this purchase agreement for failing to perform, and you can have whatever remedy is set forth on the face of Form 21. That's not what most buyers would intend to say to seller if buyer is reliant on state bond down payment assistance. What would buyer say instead? Buyer would say, seller, I'm trying to get an FHA loan, and in addition, I'm trying to get state bond down payment assistance. And if I'm unable to get either one, I can't close this transaction. With that as the understanding of what buyer is trying to communicate to seller, which form is the right form to use? The correct form to use is Form 22A. And on Form 22A, the financing contingency addendum, buyer will disclose buyer's reliance on the FHA financing and the state bond down payment assistance program for buyer's down payment. If buyer is then unable to obtain either source of funding, buyer's failure to perform the terms of the transaction, buyer's failure to close, will be excused by the financing contingency addendum. If you have questions on this topic or any other, send an email to me. Thank you for being a Washington Realtors member. Whoops, I forgot to give you our email address. Legal hotline at warealtor.org. Thank you for being a Washington Realtors member.